Well, hello everyone, and welcome back to AJ507 Ethics in Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So, this week's lecture is going to cover Chapter 11, where we're going to talk about the ethics of punishment and corrections. And keep in mind that the field of corrections, which really is going to be the topic in probably the next couple of chapters, encompasses both county and state jails, prisons, community corrections, including things like probation and parole, and some other different types of correctional programs. And correctional professionals like law enforcement and legal professionals also have a great deal of discretion and power over the lives of the offender. So with that being said, let's go ahead and jump right into our lecture. So a couple of things that we hope to learn would be to provide the definitions of punishment and treatment and some of the reasoning behind those. Describe how the ethical frameworks justify punishment. Describe the ethical rationales for and against capital punishment. Identify major themes from the ethical codes for correctional officers, treatment professionals, probation and parole officers, and explain how occupational subcultures affect that adherence to what we might call the professional code of ethics. So as you may already know, and if you don't, the United States has about 2.1 million people in prisons and jails. We basically incarcerate more than any other countries. And the reason our imprisonment rate is so much higher is not because necessarily the higher crime rate, but because of our inclination to punish with incarceration rather than any other sentencing type alternative. Now, that may not be everybody's take on it, but typically that is one of the overriding factors. Now, a careful analysis of sentencing patterns by an author by the name of Plath in 2011 shows that the dramatic increase in incarceration rates that began in the 1980s was largely due to the decision of prosecutors to seek prison terms for convicted offenders and, to a lesser extent, increased sentence lengths and changes to release and revocation. And then if you want to, I put in a couple of websites, and I have a couple of slides that have a snapshot of the website. But if you go here to mass incarceration, the website, and we'll see if it'll take me there really quickly, and then we'll come back. This really does have a lot of good data in it, okay? And there's just a lot of information. You can even learn about COVID-19 and corrections, etc. So a lot of good stuff to kind of keep in mind, all right? So the link is there for you. Now, it is important to remember that imprisonment patterns we see are a function of individual discretion on the part of sentencing judges, legislators who passed mandatory minimum laws, and also prosecutors who choose how to charge and whatever sentence that is that they are going to recommend. And that kind of makes sense, right? And we know and we've learned that there is discretion. So with that being said, okay, did the incredible rise in incarceration rates, cause crime to decrease? The consensus seems to be that incarceration rates were partially responsible for the dramatic decline in crime in the early 1990s, but then quickly reached a point of diminishing return. So, it worked at first, right? But then at some point it stopped working, and you had basically kind of a diminishing return. And for a little bit more information, I also threw in this document from the U.S. Department of Justice. It's the correctional populations in the United States. and it focuses on the year 2019, so it's fairly up to date for the Department of Justice, and they've got some different statistical tables in there for all of us to look at if you want to. And then again, in that first link that I showed you, here's just kind of a snapshot on how many people are actually incarcerated in the United States in state prisons, local jails, federal prisons and jails, and then it breaks it down to youth, etc. You can also, kind of look at the differences in incarceration from way back to 1925 all the way through 2015 relative to state prisons, local jails, and federal prisons. So some interesting snapshots. And then also you can look at incarceration rates by ethnicity. And this is from 2010. Okay, so as we start to kind of get into this chapter and we talk about the ethics of punishment and corrections, two very famous quotes, if you will, kind of resonate in any discussion of ethics in corrections. And the first is from Dante's Divine Comedy, "Abandon all hope, ye who enter here." Now, this inscription is at the portal to hell and is often basically etched in or scrawled as graffiti in prisons. So it should kind of make you think, what really is the prison system all about when you have that kind of quote there. And then second would be from Fyodor Dostoevsky, who was reputed to have provided the second quote here: "The degree of civilization in society can be judged by entering its prisons." So a couple of interesting quotes for us just to kind of think about as we start to jump into some of these chapters. Okay, so now what we want to do is take a look at elements of punishment. And according to one author, there are 5 elements which are essential to the definition of punishment. So first, let me give you a couple of quick definitions. Punishment defined would be unpleasantness or pain administered by one in lawful authority in response to another's transgression of law or rules. And then another definition to follow up would be what we call treatment. And this would be anything used to induce behavioral change with the goal of eliminating dysfunctional or deviant behavior and encouraging productive and normal patterns. So, once someone has been found guilty of a criminal offense, the type of punishment must then be determined, right? And that kind of makes sense. And here you have a picture of, and this was a super huge case, right? You actually have the former officer Derek Chauvin getting ready to be sentenced for his role in the death of George Floyd. So what are those 5 elements? Okay, so 5 elements of punishment. Number 1, there are at least 2 persons, one who inflicts the punishment and one who is punished. Number 2, the person who inflicts the punishment causes a certain harm to the person who is being punished. Number 3, the person who inflicts the punishment has been authorized under a system of rules or laws, okay, to inflict that particular punishment in a particular way. Number 4, the person who is being punished has been judged by a representative of that authority to have done what he or she is forbidden to do or failed to do what he or she is required to do by that particular law. So basically, there's a violation of criminal law. And then finally, number 5, the inflicted harm is basically dealt out specifically as punishment for that act or omission or that violation of criminal law. Okay, so now we've kind of defined punishment, we've defined treatment, and then we've looked at one author's version of 5 elements that are essential to the definition of punishment. Okay, so you might even call these the 5 elements of punishment. So in correctional terminology, kind of switching gears to treatment, treatment is anything used to induce behavioral change. Okay, and the goal here is to eliminate dysfunctional or deviant behavior and to encourage productive and normal behavior patterns. So in prison, treatment includes, diagnosis, classification, therapy, education, religious activity, maybe vocational training, could be even self-help groups. So these are all part of treatment. And there is quite a bit of vocational training and educational training as well, which I am really happy to see because, I mean, you have to think about it. When somebody is in prison, they're surrounded by others that have violated the law. So it's not always the best environment, right, for somebody to maybe change how they view certain things. So having some of these, programs are really, really important in order for those to be successful when they are released from prison. Now, treatment is considered beneficial for both society and the individual offender. The control over the individual is just as great as with punishment. And courts define treatment as that which constitutes accepted and standard practice and which could reasonably result in a cure. And much of the treatment in the correctional environment is either implicitly or directly coerced. And basically what that kind of means by implicitly or directly, if you want a certain thing, you may have to get treatment for that. Does that kind of make sense? So that's kind of one of the rationales for that. So in order to get something, you might have to do this treatment program or be involved in an educational program or something similar. And no single program really works for every single offender because we know that everybody's different and they're dealing with different issues. So what then could be some rationales for both punishment and corrections? So the rationale for punishment and corrections comes from the social contract, basically, right? In the same way that, social contract forms the basis for police power, it also provides a rationale for further control in the form of punishment and corrections. Now, recall that according to the social contract theory, we avoid social chaos by giving the state the power to control us. And in this way, we protect ourselves from being victimized by, others by giving up certain liberties to, aggress against others. And if we do step outside the bounds of this agreement, the state has the right to control and punish us for our transgressions, if you will. Now, concurrently, the state is limited in the amount of control it can exert over individuals. And to be consistent with the social contract, the state should exert its power only to accomplish the purpose of protection. Any further interventions in civil liberties are considered to be unwarranted. Now, corrections pursues a mixture of goals, including retribution, reform, incapacitation, deterrence, and rehabilitation. And we'll kind of get into that in a minute. So, again, the social contract provides the rationale for punishment in corrections and corrections. We avoid this chaos by giving the state the power to control us. The state is limited in the amount of control it can exert. For consistency with the social contract, the state should exert its power only to protect. And then we know that any further interventions, again, with civil liberties are typically unwarranted. And as I mentioned a minute ago, corrections pursues a mixture of goals, including things like retribution, reform, incapacitation, deterrence, and rehabilitation. And the two major justifications for punishment and treatment are retribution and prevention. And we're going to define all of these in a few minutes, but these are the two major justifications for punishment and for treatment. So what then is retribution? So retribution is a rationale for punishment that states that punishment is an end in itself and should be balanced with that particular harm caused. Now, prevention is a rationale for punishment that views it as a means rather than an end and embraces any method that can deter crime, painful or not. So, kind of an interesting couple of different viewpoints, right, as we look at retribution and prevention. So the retributive rationale for punishment is consistent with the social contract theory and argues that the individual offender must be punished because they deserve it. And retribution may support punishment, but it also limits it, right? Only those who commit crimes should be punished, and only to the extent equal to the wrong. So this is kind of the retributive type rationale. And when you look back at punishments over, from way back when, we had something simple as, the stocks, if you will, where it was kind of a shaming thing where you were basically put here out in public in front of everybody, all the way to like a guillotine. So but this is part of that retribution. So what then is the appropriate amount of punishment? Well, this really is a difficult question even for a retributivist. And the difference between a year in prison and 2 years in prison is measurable, only by the number of days on the calendar, not how it's experienced. And hopefully that kind of makes sense, because that could be a long time based on, how that experience is taking place. So should this then be considered during sentencing? Because punishment of any kind really does affect people differently, right? Some of you, you got to think about it. What would be a really horrible punishment for you, and how would that really impact you? So as we start and we kind of continually talk about, retribution, we have to kind of jump into what we call the rehabilitative era. So the rehabilitative era of the 1960s to the early 70s promoted sentencing based on a prevention rationale that supported the idea that individuals should be incarcerated until they were rehabilitated. And this is, so we're kind of talking about the rehabilitative area still falling under, the category of retribution. And later on, this gave way to the retribution based on what we call the just desserts, or the justice models of the 70s and 1980s. So the justice model is basically David Fogel's conceptualization that punishment of any individual should be limited by the seriousness of the crime, although treatment could be offered. And then the just desserts model is von Hirsch's conceptualization that the punishment of the individual should be purely, retributed and balanced to the seriousness of the crime. So maybe kind of like an eye for an eye or something like that. So again, these are kind of different terms as we're learning, but we're also seeing how they fit under retribution as well. Now, as we're kind of moving forward, the 1990s and up through today has, been the kind of arena or time frame of what we call penal harm. And this refers to the idea that the system intentionally or uncaringly inflicts pain on offenders during their imprisonment. And there is very little attempt to rehabilitate under this particular system, if you will, and no attempt to minimize punishment or its harmful effects. So, as we kind of talk about this, as noted earlier, the United States stands apart from most countries in the number of individuals incarcerated. And if asked to describe the reasons for punishment, most people would probably propose either the retributive or the just desserts rationale, which basically means that they deserve it, right? Or even a deterrence argument, so the punishment was so harsh, then maybe they won't do it again. Okay, so hopefully this kind of makes sense. Now, with that being said, let's talk about the prevention rationale. So there are three common justifications or rationales for punishment, that all to be subsumed under the general heading of prevention. And this basically assumes that something should be done to the offender to prevent future criminal activity. So, and what would those be? So here they are. They're these preventative methods that we're talking about, okay, would be deterrence, incapacitation, and treatment. And each of these, as we're going to find out, is based on, again, certain assumptions that must be considered in addition to the relevant moral questions. For instance, it is a factual question as to whether people can be deterred from crime, but, it is a moral question as to what we should do to an individual to ensure deterrence. So just something for us to think about. But let's look at deterrence, incapacitation, and treatment. And within this big umbrella, really quick, there's two types of deterrence. Okay, one is specific deterrence and the other is general deterrence. So specific deterrence is defined as preventing a particular offender from deciding to commit another offense, basically teaching through punishment. Okay, and general deterrence basically prevents others in a general sense or form deciding to engage in wrongful behavior. So more like, teaches by example. So hopefully that kind of makes sense. A little bit more, specific deterrence again is what is done to offenders to prevent them from deciding to commit another offense. And general deterrence is what is done to an offender to prevent others from deciding to engage in wrongful behavior. So a couple of different types of deterrence. All right, so that's the deterrence part. What about incapacitation? So another rationale is to prevent further crimes through what we call incapacitation. And this is holding an offender until there is no risk of further crime. And, there are some reasons for basically this. Strictly speaking, incapacitation does not fit the classical definition of punishment, but, for the purpose, it's not to inflict pain, but only to hold the offender, right, until there's no more risk, meaning that they've grown out of their risk category or what have you. Now, the major issue concerning incapacitation is prediction, because two possible mistakes are, releasing an offender who then commits further crimes and not releasing an offender who would not commit any further crimes, right? So it's kind of a catch-22. So sometimes it's almost even a guessing game. So how do you figure, these two different things out? Carrying out the goal of incapacitation to its logical conclusion, one would not have to commit a crime at all to be declared potentially dangerous and subject to incapacitation. Now, we now incarcerate career criminals for life, not for their last offense, but for what they might do when they're going to be released, right? And that's kind of another issue to at least consider. But there are individuals that are just so crime-ridden, if you will, that they kind of fall into this category. So this prediction thing has really become a lot more sophisticated. A lot of times now they're using some different types of systems in order to basically gauge whether they believe that they should let somebody out or not. And, kind of give you a little bit more information on that. There are grave legal and ethical issues in using, any predictive devices to sentence an offender or even to increase supervision levels or make decisions about parole if the prediction instrument uses factors like, let's say, unemployment, or maybe, zip code where you live. So that you can see how that may not be kind of fair, right? One thing that kind of came out of this would be the three strikes laws. And three strikes laws are defended under the incapacitation rationale, right? Because it's argued that repeat offenders are more likely to commit future crimes, so really they should just be held for long periods of time. And although there have been some changes in the three strikes law, especially in California, more than half of all states now have some type of three strikes or a habitual offender or a habitual felon law. One of the issues with California three strikes is that your third strike could have been kind of a very low-level felony, if you will, and you could end up going to prison for 25 to life for something simple like shoplifting or what have you. So these are things that kind of had to be worked out. Now, a little bit more, when you talk about three strikes, California's three strikes law has received really the most attention nationally. The U.S. Supreme Court ruled back in 2003 that California's three strike law was not, disproportionate and differed to the state's authority in setting punishment. The case was Locklear versus Andrade and Ewing versus California. But, California's three strike sentencing law was originally enacted back in 1994. And the essence of this law, again, was to require a defendant convicted of any new felony having suffered one prior conviction of a serious felony to be sentenced in state prison for twice the term otherwise provided for the crime. And if the defendant was then convicted of a felony with two or more prior strikes, right? So this is the strike three. The law mandated that a state prison term of at least 25 years to life be added, but some of the felonies really weren't serious felonies. So on November 6, 2012, the voters approved Prop 36, which substantially amended the law with two primary provisions. And the requirement for sentencing a defendant as a third strike offender was changed to 25 years to life by requiring the new felony be a serious or violent felony with two or more prior strikes to qualify for that 25-year to life sentence as a third strike offender. Okay, and the addition of a means by which designated defendants currently serving a third strike sentence may petition the court for a reduction of their term to a second strike sentence if they would have been eligible for a second strike sentencing under the new law. So I know it's a little bit confusing, but just kind of understand the premise, if you will, of three strikes. Okay, so we spent a lot of time talking about, the rationale for retribution, right? And we learned a couple of different terms. We learned what punishment is. We learned what treatment was. Again, we talked about the rationales for punishment and corrections. And we did spend a little bit of time on retribution. Learn the two different, justice models. So the just deserts and the justice model. And learned about deterrence and incapacitation. And then finally the three strikes law. But now let's kind of move over to treatment. So if we can find justification for the right to punish, can we also find justification for treatment? And that's a question that I want you to kind of think about. Treatment is a very different approach from the moral rejection implicit in retributive punishment, right? Because retributive means basically to punish because they deserve it, etc. And treatment implies acceptance rather than rejection, support rather than anger or hatred. Now, the retributive and prevention, including deterrence, incapacitation, and treatment rationales for punishment, are well established and can be found in all different correctional textbooks. The ethical systems that were introduced in Chapter 2 basically form our underlying philosophical rationales for this ethical framework in corrections. So, we're going to kind of talk a little bit now about some terms that are going to be important for you to understand. So the first would be utilitarianism. And by definition, treatment, incapacitation, deterrence, we punish to benefit the majority. So the principle of utilitarianism is often used to support the prevention rationale of punishment, deterrence, incapacitation, and treatment. And according to utilitarianism, punishing or treating the criminal offender benefits society, and this benefit outweighs the negative effect on the individual offender. Okay, so we're looking at something that benefits, not just the offender, but society as well. So that's kind of a quick definition of utilitarianism. Now, ethical formalism, another one, which is retribution, meaning we punish because the offender deserves it, right? So while utilitarianism supports prevention goals, ethical formalism clearly supports a more retributive view of punishment. And it is what they call deontological, because it is not concerned with the consequences of the punishment or treatment, only its inherent morality. So, and I know that sometimes it's kind of hard to understand these. So, it would support the idea that a criminal is owed punishment because, due to, to do otherwise basically would not be according, him or her equal respect as a human. However, the punishment should not be used for any other end but retribution. Remember, treatment is not supported by ethical formalism because it can be viewed as basically violative of the, second element in the categorical imperative, meaning do not treat others as a means. And involuntary treatment may be seen as using the offender as a means to, protect society. And we kind of talked about that a little bit. So hopefully that doesn't kind of mix you up, but just kind of try to remember some of the different definitions. And then we come up with an additional type definition. Okay. And this is going to be what they call ethics of care. So kind of an interesting thought here. So the ethics of care would probably not support punishment unless it was essential to help the offender become a better person or help the victim become whole. This ethical system basically defines good as that which meets everybody's needs, everyone's needs, victims and offenders alike. Okay? So, this ethical system, again, defines good as that which meets everybody's goals. Okay? Another thing to talk about would be what they call Rawlsian ethics. And this is basically a loss of rights should take place only when it is consistent with the best interests of the least advantage. Now, John Rawls, in his work, presents an alternative to utilitarianism and retributivism. And basically, no one should be treated as a means, and with the idea each should have basically, quote, equal right to the most basic liberty compatible with a similar liberty to others, unquote. So I know that was kind of a lot of legalese and correctional, terms, if you will, but those are definitions that we really need to understand. But now we're going to get into punishments and talk a little bit about the different types of punishment, why we use punishment, etc. And then we'll probably take our first break after that. So we have basically discarded many punishments that were accepted in earlier times, such as, think about it, flogging, hanging, banishment, meaning they send you out of your community, cutting off limbs, drawing and quartering, and the stocks. And although we still believe society has the right to punish, okay, what we do in the name of punishment really has, changed drastically, without a doubt. And I think we know that. And if you kind of take a look at some of the different things, if we go back and we look at, draw and quartering, we look at the guillotine, the stocks, or even whipping. So all of these things have, kind of changed over time. Now, just a little bit more before we kind of get into the meat of this. Although again, we still believe that society has the right to punishment, again, we know that things have changed quite a bit. And as a society, we become basically gradually uncomfortable with inflicting, physically painful punishments on offenders. And as these punishments were discarded, imprisonment was used as the substitute. So hopefully that kind of makes sense, right? However, we still employ capital punishment in, at least in some different states. So the American criminal justice system has adopted prison as kind of a standard form of punishment, right? And inside prison, we have only, relatively abandoned physical punishments as a method of control, at least formally. But that is to say that prisons aren't injurious, meaning that you can't be harmed or something like that. And, in addition to the, illegal corporal punishment that might be inflicted by staff, and even fellow inmates, prison is painful because it consists of banishment and condemnation. So, when we look at punishments, I think the things that kind of come to light would be what you see here, the big ones, right? When we talk about capital punishment, whether it's the gas chamber or the electric chair or firing squad, which they still have in Utah, or lethal injection. And, no matter what the punishments are, or could have been, or could be, imprisonment is painful because it involves banishment, condemnation, separation from loved ones, deprivation of your freedom, right? And really kind of an assault, if you will, on one's self-esteem. And it really prevents the person from almost all forms of self-definitions, right? Such as maybe a father, a mother, or a professional, etc. So it really is pretty intense when you think about it. So I think what we'll do right now, we're right about the 40-minute mark. We'll finish up with the Eighth Amendment, and then, well, you know what? We'll take our first break right here, and then we'll come back for part two. So this is going to end part one, chapter 11, the ethics of punishment and corrections.